Session 5, Constitution. Introduction. In this study session, we will explore how the relationship between the rulers and subjects of the state is established via the Constitution. We will examine how the Constitution determines the nature of the state, that is, whether the state is to be the federal or unitary, and how it informs the power structure in the state, that is, the structural balance of power between the central and the component divisions. We will also discuss the purpose and sources of law. Learning outcomes. After you have studied this study session, you should be able to 1. Define the term constitution, 2. Present reasons for the inclusion of a new constitution, 3. Identify at least 5 types of constitution, and 4. Highlight at least 2 sources of law. Features of Constitution. The term Constitution refers to a document which has a special legal sanctity and which spells out the purposes or framework of government and the division of power between the various organs of government, such as the legislature, judiciary, and the executive. Every new state has a constitutional code because it is method by which a country is governed. By 1994. The Constitution is the fundamental law of a state. 1. It defines the composition and also distributes power between the various organs in the political institution existing in the state. 2. It protects the rights of citizens from arbitrary violation. The types of rights it protects are such as rights to life, liberty, property, assembly, pursuit of happiness, etc. 3. It guarantees the power of government in the state and how these powers are to be established. 4. It establishes the relationship between the rulers and subjects of the state. It determines the nature of the state, that is, whether the state is to be federal, unitary, republican, or monarchical one. 5. It tells the aspiration and political of the people. Need for Constitution. 1. It is the Constitution that limits the arbitrary action of the government. The Constitution serves as a guarantee of the right of government to rule. 2. It expresses the power structure in the state, that is, the structural balance of power between the central and the component state or territory divisions. 3. It states the major objectives of government. It protects individual rights of the members of the society. Oyewole, 1985. Types of Constitution. The written Constitution. The fundamental laws and principles concerning the organization of government are written in the Constitution. Power of government, agencies, and rights of citizens are written down. Unwritten constitution. Fundamental principles of rules and regulations, powers and functions of government are not codified in one single document. Rigid constitution. The constitution which is very difficult to amend or change. Flexible constitution. The flexible constitution is the type of constitution that is relatively easy to amend or change. The flexibility of the constitution depends on the ease of the process of amendment or change. Unitary constitution. The unitary constitution grants all constitutional powers in the hands of a single central government. Federal constitution. Constitutional powers are shared between the central and the component states. Confederal constitution. The confederal constitution expresses the relation between sovereign states that are autonomous. Sources of law. Convention of the Constitution. These are the set of rules and customs outside the law and which can be stated with much precision as the rules of law. The conventions are created by those in authority and those who put the law into operation. Their precedents are followed by offices, and when they become old enough, they become tradition which are respected and followed. Oyewole, 1985. A large part of the British Constitution depends on conventions. Constitutional conventions enable the Constitution to bend without breaking and to adjust it to changing needs without a complete overhauling. It also helps the Constitution to work smoothly. Legislative decisions. A source of law is bias described by legislation. Legislative decisions can include acts of parliament, status of great antiquities, and enactments of subordinate law-making bodies such as bylaw passed by local authorities and others made by ministers, statutes, or acts of parliament are the most important sources of British Constitution. The Nigerian defunct National Assembly passed some laws between 1979 and 1983. Legislative decisions are called statute law. These are the previous decision of courts of law. These are often laws and customs of the people, which have received the judicial recognition in the reason given by judges for their decision in particular cases. They are also known as the laws made by judges through their interpretations. A source of rules of law is the opinions and writings of renowned academicians, but this opinion do not become laws until they are accepted as such by the court. Just like judicial decisions, academic writing can be evidence of customary law and can also play subsidiary roles in developing new rules of law. The rules of laws. The rules of laws give every citizen certain freedom and right to enjoy in order seeing to that justice is practiced. Adelibugbe 2002. That is where a democratic government is different from a dictatorship in which people are forced without any regard for their right to obey laws which come directly from a dictator. Some of the rules of laws are: 1. All citizens are equal before the law. The rich or the poor, the great or the humble, have to obey the law. A state minister must not break the laws without a punishment. 2. If, when necessary, the court of law tries to defend the right of an ordinary man, even against the government, in order to see that justice is done. 3. Every citizen is given his right by the law. No police can search the house of any citizen or arrest him without a search warrant signed by the magistrate. 4. No one can be punished except for the break of law and must be established by a court of law. 5. All offenses or crimes must be tried in a court of law, and the criminal or offender must be allowed to defend himself. Sometimes a criminal of a serious crime is allowed to be tried by a jury of 12 ordinary men or women who should not be partial. Study session summary. In this study session, we discussed Constitution as a document which spells out the purpose or framework of government and the decision of power between the various organs of government. The features of the Constitution were also discussed. We noted that Constitution serves as a guarantee of the right of government to rule. Types of Constitution are also discussed in this study session. Finally, we explained the sources of law, which includes Convention of the Constitution as a source of law and legislative decision. That ends study session 5. Thanks for listening.